In this presentation, we will explore the world of intellectual property. What do you think when you see these words? Well, from now on, you will think of intellectual property. These are all issues related to IP. Intellectual property is largely what drives companies like Microsoft, IBM, Apple, and thousands of other high-tech organizations. But it's also the backbone of value for companies across the creative industries. Many creative products fit the standard of intellectual property. IP is intangible, though it may be fixed in a tangible form. It is the idea behind the fixed form that is being protected. IP is also a legal concept that give IP owners rights to their ideas and products. There are several types of IP. Copyright is where we will focus in this class. It is a creative expression when fixed in specific types of works. Patents protect inventions. Trademarks protect marks or symbols. And design IP protect a distinct or unusual shape or symbol. A core principle of IP is that intellectual property is property. Property is defined as belonging to someone. So, IP gets its property character not in terms of the thing or idea itself, but in terms of its relationship to someone. Next is intangibility. Ideas are at the heart of intellectual property. Ideas are intangible, and they are a public good. A public good is one that can be consumed again and again without changing its character. Once an idea is shared, however, it is completely exposed, hence it is public. Government. Government plays a pivotal role in the creation of IP, since intellectual property exists because a government or a law court says it does. Where there is no law, there is no property. Because of the law, patents last 20 years. Copyright is the term of the author's lifetime plus 70 years. International conventions also play a role in intellectual property law. Governments have established international conventions to protect their nationals' intellectual property wherever it may be traded. However, in order to be protected, an inventor must register his invention country by country. What are the justifications for creating intellectual property law? First is an incentive. The incentive of owning what I create, of obtaining private property rights, is believed to encourage innovation. IP also serves as a reward for authors and inventors to recoup investment, make a profit, whether or not the law encouraged them to innovate in the first place. IP law encourages and protects disclosure. Ideas can be shared without fear of loss so that others may understand how the objects work to take it further, especially for patents. And there are natural rights that are presumed to be associated with something a person creates. The moral presumption is that people have a natural right to their own creation. Natural rights are strongest in products of human expression and weakest in industrial property. There is a balance between two principles when defining IP. Individuals should be rewarded for their creative efforts and will only work if they are rewarded. Whereas society as a whole can benefit if creations and inventions are put in the public domain and made freely available. The law tries to balance property rights to generate adequate incentives for creating knowledge, and to avoid monopoly power, which leads to overpricing and complacency. Although intellectual property gives rights to the owners, owners have a choice of whether they enforce their rights. A relatively new approach to copyright is called Creative Commons. Under licenses that Creative Commons provides, IP owners can give the public permission to share and use their works while they still retain ownership. In this case, they are moving from an all rights reserved model to a some rights reserved approach. This is especially common in the software industry. The open source movement, which spawned the Linux operating system, makes computer software code available under license that allows people to share and openly alter the code for any purpose. The goal is to create a collaborative effort to build and distribute software around the world. Linux uses open source code at its core and allows people to use the operating system for free. Let's turn to focus more closely on copyright, as that is the form of IP that is most widely used across the creative industries. To begin with, let's understand what copyright is. Copyright is a legal protection that is automatic. Anyone who creates an original work of authorship is automatically covered by copyright. There is nothing to register. It is automatic and applies to everyone. Copyright conveys to the owner the exclusive right to reproduce or distribute the work, create new works based on the original, and to perform or display the work in public. Anyone who violates the rights given to the copyright owner is committing copyright infringement. However, there are a few limited cases that allow people to use copyrighted materials under the doctrine of fair use. We will look at that more shortly. Copyright protects a range of works that you see listed here. The ballerina is there to remind us that choreographic works are among those that are protected by copyright. But, to be clear, the ideas contained in a copyrighted work are not protected, only the work itself. So the steps the ballerina takes are not protected, but the choreographic score in which the steps are written is protected. And to be clear about copyright ownership, it provides no rights for anyone to do anything. Instead, it provides the copyright owner the right to stop others from doing things with their protected works. Well, who actually does own a copyright? To begin with, any author or creator, as I said, automatically owns copyright to their work. And if more than one person is part of the creation, they automatically share copyright. And the owner may assign their rights to anyone whom they like. In the end, copyright lasts for the life of the author or creator, plus 70 years from the time of the author's death. After an author dies, these rights transfer to the living heirs for the remainder of the copyright protection period. Importantly, IP protection, in particular copyright and patents, is rooted in the U.S. Constitution, which is intended to promote the progress of science and useful arts. The first copyright law in the U.S. was passed in 1790 and was based on the British system, which gave 14 years of protection and allowed for a one-time renewal of another 14 years. As I briefly mentioned, there are cases in which copyright does not apply. First, the fair use doctrine permits the use of copyrighted materials in many circumstances. and copyrighted works that have outlived their copyright protection time become available to anyone in the public domain. Fair use must pass 4 tests to be considered valid. In the cases that pass the tests, some or all of a copyrighted work may be used. The first test is the purpose and character of the second use. If it is merely a copy that is not for commercial use, that may be allowed. The second test looks at how creative or factual the original work was. The third test looks at whether the amount used was appropriately limited or if it exceeded that amount. And finally, the fourth test considers whether the use will harm the market for the original work, where the second becomes a replacement or a competitor to the first. These are the dimensions that the courts consider when they face a copyright infringement case. A very famous case that set a precedent for fair use was the Sony Betamax case. Universal Studios and the Walt Disney Company sued Sony, saying that its video cassette recorder was a tool of piracy. In a landmark decision, the Supreme Court disagreed and allowed VCR ownership, saying that people were merely time-shifting their use of copyrighted works and were not otherwise harming the copyright owners. In a more recent case, Google Books won its case in court, where the judge agreed that Google Books, which provides books online that can be searched, constituted fair use. In particular, he noted all the benefits that were generated, such as driving the progress of the arts and sciences, without adversely impacting the copyright owners. The judge noted that it preserves books, provides access to books, creates new audiences, and encourages new streams of income for the copyright owners. He concluded that, indeed, all society benefits. So let's review what copyright is. Copyright is a legal protection that is automatic. Anyone who creates an original work of authorship is automatically covered by copyright. There is nothing to register. It is automatic and applies to everyone. Copyright conveys to the owner the exclusive right to reproduce or distribute the work, create new works based on the original, and to perform or display the work in public. Anyone who violates the rights given to the copyright owner is committing copyright infringement. However, there are a few limited cases that allow people to use copyrighted materials under the doctrine of fair use. And that brings us to the end of this presentation on intellectual property.